morning, ladies and gentlemen. On behalf of the Faculty of Law, General Sir John Kothalawada Defence University, I warmly welcome all of you to the Technical Session 2 on Law of the 16th International Research Conference of KDU. We feel honored to have Dr. Athula Pathinayake, paper presenters, other distinguished guests, and participants here at this session, based on the theme of Business Law Reforms for Economic Development. Now, I would like to give a brief introduction about Dr. Athula Pathinayake, the Honorable Chairperson of the session. Dr. Athula Pathinayake is the Principal of Sri Lanka Law College. He holds a PhD and a Master of Professional Education and Training from the Deakin University, Australia, an LLM from the University of Sydney, Australia, and an MBA from the University of Sri Chairperson, Sri Lanka. He is also an attorney at law, counting over 35 years of legal practice in Sri Lanka. Now, I would like to cordially invite the Honorable Chairperson to begin the session.
Good morning to everyone, and the judges, participants, and the officers and the academics of KDU. Thank you for inviting me for this session, and in fact I was here last year as well. Now, in this technical session, the topic is business law reforms for economic development. I could remember when I was doing my master's in law at University of Sydney. In fact, I touched on this topic for my dissertation as well. There we discussed, I did a comparative study with Sri Lanka and Australia and other jurisdictions. The topics that you all are discussing today is not the ones I discussed during that time. So over 30 odd years, things have changed because of digitization. You could see the topics that we discussed today. One is trade secrets, even during that time it was there, and also naturalism in Roman law, ownership of modern copyright law, and the other one is drug trafficking, how digital currencies can be used, and the fourth one is future of workplace health and safety. Quite interesting topics, and I had the opportunity to go through each of the abstracts. So I am looking forward, and of course the judges of this panel also looking forward to see the research component of it. Now, please understand, research is quite different from policy statements. Research papers are different from policy papers. So that is something everyone needs to understand, especially the students. Now, before I don't want to spend too much time on this. Now, I was told that each presenter has 10 minutes. At the end of 8 minutes, the bell will rung, and at the 10th minute, twice the bell will rung. At that time, you need to stop it, irrespective of whether you have concluded your presentation or not. But I'm sure every one of you will be able to conclude your presentation between 8 minutes and 10 minutes. I will now invite you to do the presentation. First topic is confidentiality of the Sri Lanka, a comparative analyst. Ms. J.I. Kumarasinghe is the presenter. She is an attorney at law in Sri Lanka. She holds an LLM in International Business and Commercial Law from University of West London, United Kingdom. And also, she has completed a LLB degree from this institute, that is General Sir John Kodala University. She also has completed a diploma in commercial arbitration from ICLB Arbitration Center. Her research interests are commercial law, arbitration law, and intellectual property. And now she will present her paper on the topic, the confidentiality of trade secrets. Over to you.
Thank you very much for the introduction, sir. Good morning, distinguished guests and all attendees. It is an honor to present my research paper in front of an eminent panel, including lecturers from whom I learned the basics of law. My research paper is titled Confidentiality of Trade Secrets During Court Proceedings in Sri Lanka, a Comparative Analysis. To commence my presentation, I would like to give an outline to my research. Background to the research, followed by the research objectives, research methodology, discussion, and finally the conclusion and the recommendations. When one reads the topic, there are two main questions that pops up. One is, what are trade secrets? And the second one is, why confidentiality of trade secrets should be preserved during court proceedings. There is no clear-cut definition for the term trade secrets. It contains a wide range of information. In the Sri Lankan context, the Intellectual Property Act number 36 of 2003 in section 160 subsection 6 refers to the trade secrets as undisclosed information. Secrecy is an integral part of trade secret protection. In court proceedings, disclosure of trade secrets can occur in instances such as in pleadings, in court hearings, and in the final judgments of the court. Trade secret holders should disclose their trade secret to establish before court that the plaintiff possessed a trade secret that comes under the criteria specified in the IP Act of Sri Lanka, and also the defendant misappropriated that particular trade secrets. Hence, there is a high risk of losing secrecy in the trade secret preserved by businesses for decades by a simple disclosure that occurs in a court proceeding. The research objectives of the research includes to identify and analyze Sri Lankan law on the preservation of trade secrets during court proceedings, and to analyze best practices adopted by the United States and the United Kingdom. Finally, to suggest recommendations based on the research findings. Moving on to 6, Sub-Article 1 stipulates that court proceedings should be public proceedings. Also in Article 106, Sub-Article 2, it empowers the judges to exercise the discretion to exclude public from court proceedings under instances which are specified in the article. The associate list does not mention about litigation or trade secrets as an exceptional circumstance. And moving on to the trade secret protection under Civil Procedure Code, trade secret holders can resort to Section 839 on inherent powers of court and make an application to court to grant private proceedings. However, these inherent powers are solely exercised based on the discretion of the court, and hence it is unlikely that it will be followed in each and every case with regard to a trade secret issue. When we move on to the Sri Lankan judgments, it is clear that the disclosure of trade secret during court proceedings adversely affects the rights of trade secret holders. For an instance, in the case of linked natural products versus tropical herbs, the plaintiff opted not to disclose the trade secret during court proceedings. Thus, the court was unable to hold in favor of the plaintiff as the material produced before the court was insufficient to hold that a trade secret has been misappropriated. In the US context, extensive procedural steps are adopted to protect trade secrets during court proceedings. Trade secret holders can make a request to court to limit the disclosure and to have private proceedings. Court can grant protective orders under Rule 26, Sub-Rule C of the Federal Rule of Civil Procedure. And also sanctions can be imposed on any party or attorney who discloses or uses trade secret for purposes which falls outside the purview of the protective orders. The Defend Trade Secret Act 2016 in Section 1835B facilitate trade secret holders to tender submissions to court under seal. So ex parte seizure orders can be issued by court to prevent dissemination of information, and especially these orders are issued only in exceptional circumstances where higher threshold is inexistent to avoid irreparable damage caused to the other party. Moving on to the UK approach, two parallel regimes, the common law and the statute, are used to regulate protection of trade secrets during court proceedings. The Trade Secret Enforcement Act 2018 in regulation number 10 specifies strict measures to restrict the disclosure of trade secrets. Court can restrict access to documents and court hearings. Court can make available a non-confidential version of the judicial proceedings. Confidentiality clubs are used where the accessibility are limited to selected persons who have signed an undertaking to access such information. In the case of Infederation versus Google, the court held that confidentiality rings are exceptional arrangements to open justice. Therefore, confidentiality rings are used in limited circumstances and the narrowest extent possible. When the US and UK approaches are compared, the UK approach is considered as a balanced approach. The reason being it gives due recognition to the rights of trade secret holders as well as the principle of natural justice. In conclusion, unlike in the two selected jurisdictions, the existing Sri Lankan legal framework does not contain legal provisions with regard to protection of trade secrets during court proceedings. It adversely affects the enforcement of the substantive law ensured under the IP Act, resulting in holders reluctant to disclose, and the enforcement mechanism becomes fragile. In recommendations, I have suggested the inclusion of a comprehensive provision on preservation of trade secrets during court proceedings into the IP Act. The comprehensive section can include protective orders, confidentiality clubs, ex parte seizure orders, and private court
questions, now it is the floor to ask any questions. There are no questions, but I will ask a question. Now, if you take the United States of America, they have things to preserve, protect. Institutes like, or organizations like KFC or Coca-Cola. Coca-Cola, as far as I know, only 10 people know the secret, the formula. Now, country like Sri Lanka, I mean, we take the theme of this topic, that is business law reforms for economic development. Which area do you think that the people or the people who want to protect their interests, what area do you think that would be quite interested in Sri Lanka?
So in the Sri Lankan context, small and medium scale enterprises and traditional knowledge-based enterprises heavily depend on trade secret protection. There are scholars who have proved that point, and although we don't have empirical research done in that regard, there is the innovations or the creations by small and medium scale enterprises, and these traditional knowledge-based enterprises does not qualify for the traditional trade secret, traditional intellectual property rights that are enshrined to be qualified at their protection to be guaranteed under the IP Act, such as patents. There should be an innovative step, should be a novel one. So those aspects for small creations, which these small and medium scale enterprises make, they can't get those patents. So traditional this trade secret can be used in that regard. And also in trade secret, the protection is for unlimited time period. So if someone doesn't want to restrict their right for about 20 years or something, a specific period of time, and we wish to have the protection for an unlimited time period, so this can be used. And in the pharmaceutical industry as well, to protect their secrets. And the case in Link Natural also.
If each person try to protect the trade secrets, don't you think it would hinder economic development of a country? Like a small country, like I can understand Coca-Cola, it's a massive scale industry, KFC massive scale industry, or even IT massive scale industries. But small country like us, if we try to protect, everyone says, okay, I have a secret, I'm not going to give it to them. It's about sharing of information with others. So, don't you think it would hinder economic development?
Thank you very much for the question, sir. It is certainly in the economic development. That's why I'm proposing a balance between the rights of the trade secret holders as well as the public. For instance, let's say a pharmaceutical company in Sri Lanka develops a new medicine, and they are reluctant to disclose it, and they are trying to protect it by way of trade secret protection. Then at that time, the health of the public and the people who consume that drug will be in an adverse position. So that's why the natural justice principles are also being used to balance it. Especially my research is on confidentiality during court proceedings. So disclosure of disclosure of the trade secret is essential in court proceedings to establish that a trade secret falling under the criteria specified in the IP Act is present with the plaintiff. I hope I have answered your questions. Thank you.
Thank you. Any questions from the audience? presentation is yeah. So, yeah, this is a recorded presentation by Rathnamalala and Ms. Wijesooriya, and they will be presenting a paper on a time travel to Nova species, influence of naturalism in Roman law on the ownership of modern copyright law. So it's a quite interesting topic where both of them are going back to the Greek and Roman history, and they have this concept of natural law. Natural law is something above the law, it's some divine law which comes with the morality. And that concept, how the modern day copyright issues, the relationship between the two. So as copyright, you can't disclose information. You have the right to protect that. So these two parts, presenters will discuss on that. And they are at the moment overseas. They be presenting their paper as a recorded statement. Over to them. Thank you.
Our presentation today is A Time Travel to Nova Species, Influence of Naturalism in Roman Law on the Ownership in Modern Copyright Law. The content of this presentation is as follows. Firstly, I am to introduce the key concepts in the research. The discussion will be based on the relationship between modern concepts of ownership and its Roman law roots. Finally, I will conclude with few recommendations for the academia and for judiciary. Roman civilization was one of the remarkable ancient civilizations on the earth. Literature and artistic creations were in its peak. Therefore, disputes on artistic creations might have been inevitable. No such different branch in law such as intellectual property law in Roman era, but it was recognized as res, in English, things, intangible things in the concept of ownership. Now, Roman law principles in the ownership influenced on modern intellectual property law ownership related areas on the literature and artistic creations. Contemporary intellectual property law jurisprudence is mainly based on domestic and international statutes adhering into positivist approaches. The question arises is that can modern intellectual property law disputes on the artistic creations could also trace in Roman law roots? This is the foundation of my research. The main research objective of this research is to see how morality-based naturalism shaped the modern intellectual property law principles such as originality in determining the ownership in copyrights. The secondary objective is to examine whether the academic and judicial interpretations on determining the claims on the copyright's ownership could go back to or trace back in its roots based on naturalistic Roman law principles. In my research method, I adhered into the legal research methodology. As we all know, it's a library-based secondary data review, or in other words, it's a desk research. The expected outcome of this research is a policy research, which is to focus on implementing policy implications. Let's move to the discussion part of this research on the possible relationship between intellectual property law and naturalism. At first sight, you may see that intellectual property law and Roman law are two different areas of or branches of law, two different polars. When it comes to intellectual property law, it is the guardian for protection of artistic creations or literature or any other types of intangible rights. Now, if you interpret it, it is a guardian for protection of artistic creations, literature and other types of intellectual goods and services by granting them a certain period of protected time frame to control the use made of those products. On the other hand, when it comes to Roman law ownership, it is one of the most ancient developments of law or foundation for most modern law concepts such as property ownership. Then again, if we turn to intellectual property law ownership, it is solely or mostly treaty based, whether it's international or in domestic law. The Roman law ownership was of naturalistic origins. The key concept of naturalism is the morality. Later, these proceeded to certain modifications, for example, 12 tables or jus civile methods. When it comes to IPL ownership, different types of protection, various areas of protection specifically for literature, artistic creations, so drawings or music. Roman law ownership, on the other hand, acquiring of ownership under natural law. For that, they had natural modes or methods, tangible properties or intangible properties among the other methods. Finally, what we can see is that IPL ownership is internationally and domestically positivist approaches due to its governing authorities are internationally or domestically treaty-based. Internationally treaty-based, domestically those are legislative enactments nature. On the other hand, when it comes to Roman law ownership, different schools of thought, various juristic opinions on solving issues. What it does look like the era before the developed branch of intellectual property or nova species. What is nova species? Nova species is the new creation or intellectual property or copyrightable property. Here I cite Versti, I quote, ancient Romans did not develop a law of copyrights. Painters and sculptors were funded by wealthy patrons who worked on municipal projects funded by the government. So, wasn't there any mechanism to resolve these issues? Well, not only one. They had few ways. We'll firstly see what are these schools of thought, such as Proculaean school of thought and the Sabinian school of thought. Now, Proculaeans and Sabinians were the two prominent juristic schools of thought prevailed in the ancient Roman law juridical culture. Proculians, they determine the ownership, such as ownership should go to the person who made the new creation. Sabinians, ownership should go to the owner of the material. Media sentia is the third opinion, whether the Nova species could be restored to the original state. The material owner becomes the original owner of the Nova species. You all have heard of Justinian. Justinian indicated that if the sculptor had contributed to any part of the material, the Nova species should belong to him. So these are the different opinions on the Nova species, the copyrightable product, the new product. Therefore, finally we could see the certain aspects on the interplay between these two different concepts of law. For example, intellectual property law ownership is ownership of author or copyrights based on the legislative enactments or it's treaty-based international law. When it comes to naturalism, the applicable theories such as unjust enrichment in order to eliminate or prevent unjust enrichment through copyrightable product. In the medieval period, John Locke's labour theory was developed by John Locke. Labour of the author creates 99 of the final product or creation. Labour of the author contributed to producing a work that created natural ownership over the property, the oath of the product. Therefore, in line with this interplay between two concepts, let's finally conclude as naturalism's core principles such as morality and natural rights are closely related to IPL's or intellectual property law's different principles on the concept of ownership. Origins of the key theories of ownership on intangible properties could be traced back to the morality-based naturalistic Roman law origins. To overcome the complexities in contemporary intellectual property law, interconnectivity between the applicable theories in intellectual property law and that of naturalism could be utilized. To bridge the gap between pure positivist approach and achieving of social justice or individual rights, ancient approaches on determining the Nova species could be revisited. IPL-related claims could be enriched through naturalistic approaches taken by philosophers in later stages as well. For example, as I described before, John Locke's labour theory. Let's quickly go to the final part of my research, the recommendations. Positivist approaches lead judiciary to rethink on progressive interpretations on domestic intellectual property law claims. To bridge the gap between pure positivist approaches as indicated before and achieving of justice, especially the individual justice as well as social justice through application of naturalistic interpretations led by ancient Roman law ideologists. They can utilize in judicial interpretations. Intertwined approaches on the areas of advanced legal research on the interplay between IPL and naturalism, its application to judicial interpretations as well as international IPL organizations, authorities such as WIPO. Introducing related principles on naturalism in course curriculums of contemporary legal education for advanced research. These are my references. And thank you very much.
Thank you very much. In fact, it is my bad that I forgot to introduce these two presenters. Ms. Rathnamalala is a senior lecturer in the Department of International Law, Faculty of Law, Generous John Kothalavala Defense University. She is currently reading for an MPhil or PhD degree in law at University of Colombo. She holds an LLM Human Rights Law from University of Minnesota, United States, and an LLM and LLB degree from University of Colombo. Her research interests are women's rights and international humanitarian law. Ms. Wijesooriya is a senior lecturer in the Department of International Law, Faculty of Law, Generous John Kothalavala Defense University. She is reading currently for her MPhil PhD degree in law at Colombo University. She obtained her LLM degree and LLB degree from University of Colombo, and she is a keen researcher in environmental law and intellectual property law. I'm sorry that I couldn't introduce you before. Now it is up to the audience to ask any clarification from the presenters. I really like the audience to get engaged. Any questions? She's not online.
Yes, I'm online, sir.
So any questions from her? All students should ask questions. I mean, she touched on, in fact, based on jurisprudence as well, quite an interesting area. And I have a question now. I'm the one who is asking questions, and I'm not supposed to ask questions. Just a clarification. You said these concepts can be used to develop law and recommended judiciary should consider those things. Now, what is lacking at the moment, I mean, where they have not considered these concepts?
Sir, I can't hear you.
USA. Probably I may have to come to USA. Now, what
Sir,
yeah.
I can't hear you properly, sir. Please repeat for me, please.
Can you hear me now?
Yeah, exactly, sir.
All right.
Now I can hear you properly.
Now, you mentioned as to how the jurisprudence, the theories in jurisprudence could be used in modern day disputes. Now, can you give some examples where we have not used these theories?
Okay,
I mean,
sir.
that should
Thank
be
you
your
for the
research.
question, sir. Actually, naturalism and naturalistic approaches are morality based, as I've already discussed. And when it comes to treaty law or acts, those are completely of positivist nature. There can be loopholes in the treaty, or as we all agree, I hope you all agree, there can be certain gaps or certain misfits in the treaty law or in acts.
So that's what I
in
want to,
which,
what are the, can
through
you give some
which
examples?
Hello, can you hear me?
Yeah, I want, if you can give some examples, this is where it has not been considered.
Well, sir, it's if I take the pure philosophical view, when it comes to Roman law foundations, you can see all these naturalistic foundations in whether it's family law or whether it's contracts or whether it's intellectual property law, as we discussed now. Okay, when it comes to treaties, I can exactly say something like, for example, when you determine the ownership solely based on a treaty, let's say it's on artistic creation, such as on a song or a script, if it is completely, sometimes it may be difficult to determine the ownership. Determining the ownership, I'm referring to determining the ownership solely based on the treaty or the act. So in that case, sometimes there can be different avenues which you can achieve individual justice as well as social justice through taking different opinions. As I have indicated, in ancient Roman law, there were few schools of thoughts like Procilians and Sabinians. So maybe it's vague, but still, if it is now the objective of the judiciary or objective of the judgment should be social justice oriented, social justice based. So in that case, different ideologies based on naturalism's morality could be utilized in creative manner. That is my thesis research argument.
Thank you, Hasini. Any questions? Yes, thank you. And your research area is quite interesting. And I would like to see that you give some specific areas. This is where we are lacking, and this is where it could be used, like specific areas, like either in certain treaties or judicial interpretations where the judges have not used these areas. So it would be more specific, and I'm sure you will be able to find, if you, based on what you have said, give some examples, because I did some reading on this before I came, and this is something that people have researched before. But in your research, you have to come up with something novel, something new, where no one has touched previously. So that will become a research. I'm sure you will come up with a fantastic paper. Thank you.
And as I indicated before, again, this is kind of a novel species for us. So we will be trying to sort of starting it from intellectual property and to expand it to other areas. And your input is tremendous. So thank you so much for your suggestions and recommendations. And thank you very much for everyone.
The next presenter is Mr. Dissanayake. He is an insurance consultant. He is reading for his LLB degree at the Open University of Sri Lanka. And his paper is, the topic is recommendations to improve legal framework in Sri Lanka on combating involvement of convertible virtual currencies in narcotic, drugs and psychotropic substances trafficking. Quite interesting because of the digital advancement and how not only Sri Lanka, other countries also face this issue, because I'm sure in his paper he would be discussing areas such as how narcotics and human trafficking has expanded in this world, and not like previously. Today, people will be able to do things by touch of a button, transfer of millions and billions of dollars from one country to another. So over to you, Mr. Dissanayake, to present your paper.
Thank you, sir. Good morning to all of you. I'm not going to introduce myself again, as sir introduced me more than I deserve, I think. Okay, let's start the session. Today I'm going to talk about Sri Lankan legal framework on combating involvement of convertible virtual currencies in narcotic drugs and psychotropic substance trafficking with suggested legal reforms. First of all, I would tell you that as this is an oral presentation, I'm not mentioning each and everything in my slide. I'm going to tell you this verbally. By the way, we talked about what I want to talk to you regarding, and then why. This is the most important thing in my research. What is the reason I conducted this research? Considering narcotic drug trafficking, it has become very, very large problem to each and every jurisdiction of the worldwide. Therefore, as responsible persons, all of us have the responsibility to support legal authorities to dilute and mitigate and reduce narcotic drug trafficking and usage. There are a few police officers there, so it is very important to discuss why I conducted this research. And the other thing is, narcotic drugs are affecting to the economical, health, political and cultural aspect of a state. That's why I selected this topic. In addition to that, today drug traffickers are using high technology to continue and conduct their illegal narcotic drug trafficking. That's the main reason I chose the topic today. Then the other thing is how. Actually, this is the research methodology. How? This is completely a library-based research. Therefore, this is conducted under the doctrinal methodology. After that, it is very important to understand what are narcotic drugs, because narcotic drugs are not banned in any jurisdiction. It is very important to understand that narcotic drugs are only controlled, not banned, because narcotic drugs are used for medications too. Therefore, the legal authorities have to pay their attention to reduce the narcotic drug trafficking and usage for any other purpose than medication. For example, just see what are narcotic drugs. A substance used to treat moderate to severe pain. Narcotics are like opiates, such as morphine and codeine, but are not from opium. It is very important to understand that narcotic drugs are combined into your central nervous system, and after that, your central nervous system will be it's combined to the central nervous system, and there will be some health problems that can be arise after the usage of narcotic drugs. It is not very, very important to tell regarding the definition of the narcotic drug. Let's go to psychotropic substances. Considering psychotropic substances, those are banned. Those are banned because psychotropic substances are not used for medication other than for medics. For example, this thing, a medical officer can prescribe narcotic drugs only for 3 days per person. Only for 3 days. In addition, if the person, that medical officer, prescribe more than that for 3 days, it's prohibited by the law. That's what we understand. Okay, let's move to the other session, other slide. Now, the main component of this research is the interference of CVC. CVC means convertible virtual currencies. Convertible virtual currencies doesn't mean the digital currencies should have to be, because most of the people here are using online transaction apps, but those are not convertible virtual currencies. Those are fiat currencies which you can transfer to real currencies, liquid cash for any given time. But convertible virtual currencies are virtual assets that only in digital platforms. Therefore, it's very important to understand blockchain, anonymity, CVC kiosks, and P2P. Okay, I will explain you how this happened. Unfortunately, there might be a technical error. There should be a photograph of a drug manufacturer in top right side. By the way, I will explain you how this high technology drug trafficking is going on. Look at Lisa. Lisa is a litigated person. Lisa wants to make a litigation to a person in another jurisdiction. She wants to face that lawyer. That lawyer. That's very legal one. Nothing illegal in there. That's okay. Now Lisa has to pay the lawyer with convertible virtual currencies, for example. Now Lisa paid. Lisa's convertible virtual currency, that means Lisa's money going to the blockchain first. Blockchain is an online ledger. It's an online ledger. That means, I will explain you regarding that later. In addition to that, there is a person called Escobar. Escobar is a drug dealer and a drug importer. Now, he wants to purchase some drug from the drug manufacturer. He has to pay that drug manufacturer with the convertible virtual currencies. Now, Escobar pays to the blockchain. That's now this is the time that the problem starts, because blockchain mixing up all the payments of all the people. Now we can't recognize whether Lisa paid to drug manufacturer or the lawyer. Now legal authorities can't recognize who paid to who. Who paid to who. That is the main component of my research, because Sri Lankan legal authorities have to pay their attention for the future risk, because in Sri Lanka it is not technically in a very big place at the moment. So this is the foreseen risk that can be happen to Sri Lanka in drug trafficking. By the way, I'll go to the other slide. Now the drug manufacturer and lawyer can put their money received from the blockchain to the CVC kiosk, which is like an ATM, and they can convert it to the cash. Now, nobody knows who paid to whom and what are the illegal money and what are the legitimate money. After that, I conducted the research on this subtopic. It's not very important to tell you regarding at the moment, because it's readable. Introduction, the history of drug controlling, not banning drug controlling, Sri Lankan legal framework on illegal drug trafficking, novel technological interference, CVC of drug trafficking, and conclusion with suggested recommendations. I'm not going to this one. This is the international legal framework. Okay, this is very important. What central bank says about convertible virtual currencies. In their website, central bank says we are not responsible for any cryptocurrency. This is the real situation of Sri Lanka. They are not only responsible, they are not even look at that. They have to pay their attention, because nowadays drug traffickers are using high technology. Because therefore the central bank has to pay their attention to develop the legal authorities to mitigate that the usage of high technology to drug trafficking. After that, the recommendation recommendations, the limitations for multiple identities and multiple mobile numbers for an individual person. It is very important because multi-identities and multiple mobile numbers with using for the online platforms, it would be a haven to drug traffickers using CBCs. After that, the declaration of purpose of payment, it is very important because you know that with the Prevention of Money Laundering Act, we have to declare the purpose, but not in terms of convertible virtual currencies. In addition to that, registration for CBC exchanges, CBC exchanges are, which I mentioned, something like the ATM, the CBC kiosk, those are not in Sri Lanka yet. So after that, the registration for domestic CBC buyers. If there is any person who going to buy CBC means the convertible virtual currencies, you have to, the legal authorities have to make a registration of buyers. Okay, this is my references. After that, the discussion with panel will be conducted after the session. Thank you to all of you.
Interesting topic. I want to reserve my question, but before that, I want the audience to ask questions. Thank you.
Good morning.
There is a question.
Yes, my question, so throughout your presentation you mentioned that this is a foreseen risk. That is non-existent right now, but a foreseen risk. And you also cited a quote from the central bank saying that they do not intend to have their purview extended towards cryptocurrencies. So do you see the need for a separate regulatory authority to oversee CBC and the risks that are joined to it, or do you think that the purview of the central bank would suffice with certain additions to their regulatory framework?
Thank you for your question. As per my aspect, we need separate legislations on that because central bank can't interfere to each and everything of the drug trafficking because we have separate legislations on drug trafficking. This has to be covered by the drug trafficking legal authorities, especially the regulations made by Narcotics Bureau. This is my perspective from Narcotics Bureau, and after that, as an amendment to the Poison, Opium and Dangerous Drugs Ordinance.
Thank you.
Thanks.
Any other question from the audience? Okay. Now I have a question, one or two. Have you considered how other countries control this problem?
Yes, I consider, but most of the countries are not using this method actually.
Sorry?
Most of countries are not using the legislations on convertible virtual currencies because now in that sense, this is a recommendation for all of the countries, but considering the jurisdictions like United States of America, it has that law. In addition to that, I never seen there is any jurisdiction which cover up this.
So is it because it is difficult to control?
Yes, it can be difficult to control, but we have to make legal suggestions and legal cover up. Because otherwise, now we have seen some drug traffickers in time, they are releasing from the prisons because due to the technical force of the case. Because that technical force may rise in two different aspects in that, the specific case, and other one means the legal authority. Legal authority means the legislation. So we have to touch, in my aspect, we have to touch each and every sensitive situation of drug trafficking to control that, because we have that main purpose to reduce drug usage. To reduce drug usage, first of all, we have to reduce drug importation of drugs. In that sense, we have to make such legislations, in my opinion, sir.
In one of your recommendations, you have said not allowing multiple usage of mobile phones. Can you do that practically?
Yes, we can do that, sir. Now, in 2019, the central bank made a regulation to do that.
One person, one mobile.
Yes, one person, one mobile, and one identity. It's very good, actually. It's very good. We would appreciate the application of that.
Quite interesting solution.
Thank you, sir.
And any questions from the audience? No? So thank you very much, Mr. Dissanayake, and I wish you all the best with your research. Yeah, probably you will become to law by very soon. Thank you. The next presenter is NKK Mudalige, Edirisinghe, and DP Aluthge. Unfortunately, I don't know whether he or she. They are presenting a paper on future of workplace health and safety, a legal perspective. NKK Mudalige is a senior lecturer in the Department of Business Law, Faculty of Law, General Sir John Kotalawala Defence University. Now I know Mudalige is a she. She is reading for an MPhil and PhD degree in law at the University of Colombo, Sri Lanka. She holds an LLM from General Sir John Kotalawala Defence University and a Master's in Labour Relations and Human Resources Management from University of Colombo. She obtained her LLB degree from University of Colombo. Her research interests are in the field of labour law and environmental law. Miss Edirisinghe is a senior lecturer in the Department of International Law, Faculty of Law, General Sir John Kotalawala Defence University. She is reading for a PhD degree in law at Macquarie University, Australia. She holds an LLM from University of West London, United Kingdom, and MPhil from University of Colombo, Sri Lanka. She obtained an LLB degree from University of Colombo, and she is enthusiastic researcher in environment law, animal welfare, and labour law. Mr. Aluthge is a senior lecturer in the Department of Military Law, Faculty of Law, General Sir John Kotalawala Defence University. He holds an LLM from University of Colombo and a postgraduate diploma in criminology and criminal justice from University of Sri Lanka. He obtained his LLB degree from University of Colombo. His research interests are environmental law, criminal law, and industrial law. The paper is on future of workplace health and safety legal perspective, and in this paper I think they would be discussing on new normal situation recognized by international communities such as World Health Organization and ILO, especially after the pandemic situation, and what is the new things and how the workplace should be a safe place for the people. And over to you for the presentation.
Thank you, sir, for the introduction, and good morning to all of you. Me and my co-authors, Edirisinghe and Aluthge, we are going to present about the future of workplace health and safety, a legal perspective. Asanka is online today, and Aluthge is with us. So, first, I'll be talking about the introduction, then this is my outline of my presentation, you can see. So let me first introduce what is occupational safety and health. So it differs, the standards of occupational health and safety differs according to the situation and requirements of the workplace. As we all know, we cannot have a specific set of standards for all the workplaces because the work done and the operation there at the workplace is different from one another. But these all such practices should protect the individuals from health hazards, risks and various environments, particularly in the workplace. And this health and safety at workplace articulates a human rights-based approach where it can be linked to right to life and a safer working environment. And on the other hand, international organization has also provided a series of normative backgrounds where the national laws can focus on health and safety measures. Here we have linked our main title, the occupational health and safety concept, with the new normal situation. What is new normal? New normal is recognized by WHO and ILO as the changes in the conservative human activities in society, individually as well as collectively, due to the constraints imposed by COVID-19 pandemic. As all of you can remember, in 2020, we were wearing face masks and we were having social distance and we could not meet each other and we had to go to a virtual setup even to have this conference. And thereafter, in 2021 also, we had to go for a hybrid version where some people could meet but with social distance and the others had to virtually join. Then last year, it was bit eradicated. Now today, we are here at this same IRC in 2023 without face mask, without social distancing, and what kind of preventive mechanisms or safer environment we have safeguarded or guaranteed? Or are we still in the 2019? The situations, working environments have been changed based on this new normal concept, as we can see. But have we taken legal measures enough to safeguard our workforce? That is the main problem we are going to address in this presentation. And my objective is clear, it's to provide legal remedies to improve our law on occupational health and safety in Sri Lanka with special reference to new normal situation. And talking about our methodology, we use the black letter approach of research where primary sources, as I mentioned in this slide, and the secondary sources were analyzed, and international and comparative research methodology was followed based on the ILO standards. We compared our were required to be safe and was required to be given a healthy working environment. Based on that, following that concept, our Factories Ordinance was enacted in 1942, and up to now, it is the only enactment that discusses directly about health and safety of employees, and it's only about factory workers, nothing else. And construction workers are also included there. And we have another enactment, Mines, Quarries and Minerals Ordinance, where the mineral workers are covered with regard to safety and health. And apart from that, a special enactment is there to cover some of the areas with regard to health and safety of women, young persons and children. So this targeted specific industries without any comprehensive or collaborative approach to work safety was the first approach to health and safety measures. And the other countries have gone far from there, but Sri Lanka is still at that first level of health and safety measures. This work safety or health and safety is not only the state's liability or the obligation to provide healthier and safer working environment, but also there's a general duty to the employers to provide a health and safety measures to employees. And we call that model, because it was introduced by Lord Robbins in one of his law reforms, which we call it Robbins model. The general duties and specific set of rules are provided by the national legislation, and it is backed up by the ILO conventions like Occupational Safety and Health Convention number 155 and the Convention number 187, where it is required to have a national policy on health and safety, and the employers are liable to provide healthier and a safer working environment based on their company policies. So the national framework will be there, and the factory workers and mineral workers and other targeted specific industries will be covered by a specific legislation. Apart from that, employers are given the liability or obligation to provide a safer working environment. If we look at our Sri Lankan context, we have the National Institute of Occupational Safety and Health under the Ministry of Labour. It's a statutory body, but it is only conducting training sessions and sometimes verifications on health and safety standards, but they don't have any power to monitor any health and safety measures at a workplace. And National Policy on Occupational Safety and Health was introduced in 2014. Thereafter, we do not have any updated national policy. Therefore, it is required to expand the coverage of occupational safety and health measures. And we can see a lack of integrated approach on these OSH measures in Sri Lanka, and we don't have an institutional framework to monitor health and safety measures. And with the COVID-19, there were several issues highlighted in the Robbins model that we follow. So the subcontracting chains in employment, since there's no legal responsibility to one employer, the health and safety of those employees who work under subcontractors is an issue. And also self-employed workers. There's no obligation on anyone to provide safety and healthier working environment for self-employed workers. So they will have to provide their safe environment, and that's the issue. And also, traditional industrial jobs, what we do, also has been challenged because of COVID-19, where we worked from home. How our employers could provide or guarantee us a safer working environment. So working from home concept has also challenged our Robbins model. And occupational disease recommendation, which was updated in 2010, has the mental element of employees been included in the occupational health and safety, occupational diseases list. So there is a concern to Sri Lanka, not only Sri Lanka but also other countries, regarding this occupational health and safety in order to improve our law. Let me conclude my presentation. So a factories ordinance, which is told in legislation, only covers, and there's hardly any guidance on health and safety matters of employees in other sectors. So there should be a provision included to the Shop and Office Employees Act and the Wages Board's ordinance with regard to safe and healthy working environment for all the employees in the private sector in order to cover them. Then for the public sector, we will have to have another set of guidance by way of circulars to maintain occupational health and safety, because it's required to empower our labor force in order to have the businesses developed, the labor market developed. That's what our objectives are. Thank you so much.
Thank you very much, Mudalige. Any questions from the audience? Two, fantastic. Can you repeat the mic?
Good afternoon, sir. Good afternoon to everyone. First of all, thank you for those insightful thoughts, ma'am. The topic was very beneficial and relevant. So my question is, since the research was specifically based on the new normal situation, do you think that the implementations we have made and the measures we have already taken down would cater the potential threats or the future conditions in Sri Lanka? Is it sufficient? Do you think that it's sufficient?
Thank you for your question. No, I don't think that as per our research, we did not find any substantive measures that have been taken to prevent any other occupational hazard or safety hazard that could happen in the future, maybe because of a pandemic or anything. So there should be legal measures improved in our country based on that.
Thank you, ma'am. Follow-up questions?
Sorry?
A follow-up. Yes.
Yes.
And also, ma'am, this is regarding the self-employed workers.
Yes.
So, as citizens of the country, all of us are supposed to pay our tax, and also regardless of the fact that whether you're working under a company or a different professional or entitled to any privileges of the state, you are supposed to pay tax, and the state is vested in the authority of collecting them. Now, setting aside the employees of the companies, since they have this ETF and VPF facilities, the self-employed workers, they also do pay their taxes correctly. And for them, as you mentioned, they should be given safety precautions and all of those. And do you think, ma'am, the state is entitled to give them a safety environment within their purview of their work? And what are the measures we have already taken down? And also, can we improve those in those aspects for the same self-employed workers?
Thank you again for that important question. For self-employed workers, we will suggest that there should be a registration process and also an insurance scheme introduced for them. Maybe the government can pay half of their relevant insurance amount, and the half of them can be paid by the employee, and that's how the other countries have actually adjusted to self-employment with regard to health and safety. Financially, we can cater that need.
Thank you.
Ma'am, so when you were presenting your
the national policy on occupational health and safety for Sri Lanka was brought forward in 2014. Yeah. And then how there's an international convention on the same matter as well. So when we're comparing the domestic policy and the international convention, what exactly are the provisions which are not there in the domestic legislation that we should enact, and if there are any specific sections or articles that you could maybe like tell, that'd be great.
Yes. So national policy was required by Convention of 155, and we haven't ratified that convention, ILO convention, but we do have a national policy on occupational health and safety we introduced in 2014. They have a general approach to occupational health and safety, and there are no specific industries covered by that. So the employer and also the employer's liability is not focused much that in our national policy. So the international framework requires the employers to give the obligation on specific prevention mechanisms and some other aspects. So that is missing in our national policy and it should be updated.
Thank you.
Any questions? I think it would be unfair if I don't ask a question because I have asked questions from all the other representatives. Now, when it comes to this concept of new normal, basically it says basically it has triggering massive and instant series of experimentations, flexible work arrangements, and in relationship to centralized working environments. Now, when it comes to a country like Sri Lanka, I really like your suggestion about health and safety requirements that we should adhere to. I mean, in this conference room, I can say, even without this new normal concept, I don't know whether employers are adhering to health and safety requirements in Sri Lanka. Provided one day that we will be able to have this system in place, what type of cultural issues you would look into in health and safety? Because I think Sri Lankan culture is very, very unique to any other country in the world. You really cannot understand the underlying current going through the Sri Lankan culture, though we say we have a culture. It's very different. So how would you balance it with cultural values or cultural norms in Sri Lanka when it comes to the new norm?
Yes, I agree with you, sir, with regard to the cultural dimensions we have in Sri Lanka. Yes, implementing occupational health and safety measures throughout or in all employments would be much challenging. And first of all, I think there can be resistance from employees as well as employers if we are to implement a new set of guidelines to with regard to occupational health and safety. And there can be financial issues because of the socio-economic crisis we are facing today. And to overcome that, there should be awareness programs and training sessions, because we can use the National Institute of Occupational Health and Safety for that, and the advice of the Ministry of Labour. And also, I think we should focus on occupational diseases, because in traditional setup in factory, with regard to factory workers, we have only these physical injuries, risks, hazards that are covered. But the occupational diseases with regard to other employments, for example, maybe teachers, IT sector, the back pains or the vocal issues, they are not covered by any of the statutes. But updated in 2010 by ILO, we have covered all those things. So I think Sri Lanka can, if Sri Lanka can focus on those also, that would be more improved.
Any questions? No questions from police officers? No? So, thank you very much. Quite interesting discussions on various aspects, especially when we discuss the presentation on business law reforms for economic development, spanning from trade secrets and ownership of modern copyright law, drug trafficking and cryptocurrencies, etc., and also the health. So it varied from one spectrum to the other. All these areas are quite important in today's perspective. And in economic development, at the moment we are struggling at the moment, but I'm sure one day we will be able to overcome all these problems. I mean, I'm very optimistic about it, and we have to think in a positive way that we will be able to overcome all these problems. And the areas that they have discussed will have a massive role to play in economic development. So I think it's almost a lunchtime, so it is not fair for me to keep you waiting. I want to thank first Dr. Mrs. Shara for her contribution, and also Mr. Gamini, Wijesooriya, Mr. Rathnamalala and Mr. Athula for their participation as well. So thank you very much for the presenters, thank you very much for the audience, and what's next is the presentation.
Thank you very much, sir. We would now like to award certificates to the presenters of the session. And I respectfully invite the Chair, Dr. Athula Pathinayake, to do the honors. I kindly request all the paper presenters to come forward and accept the certificate.